Okay, I'm going to give it a go. How's it, guys? Welcome to a Legalese series webinar. So now you know it's the series of Legalese's webinars where we present on topical issues across the practice areas of Legalese. Today being the practice area of cannabis, where I head up the Cannabusiness department, and that's me. The cannabis legal advisor. I'm consulting with Legalese, have done for 3 or 4 years, for those who don't know me. And yeah, we're in a very interesting space now in the cannabis industry and the private cannabis club space. And given recent events, particularly the High Court ruling, which rendered the agency construction, which rendered the Grow Club model of Private Cannabis Club to be illegal in the High Court. It seemed a bit topical to run one of these webinars where we go into the judgment in a bit of detail, and that's really what I want to try and assist you guys to understand, presuming that a lot of you guys joining, colleagues, friends, and current and potential cannabis club founders might have read or might not have read the judgment and want to really understand how far the judge went, and she went extremely far, we can say up top. So this is the Haze Club saga and the court war for private cannabis clubs. So welcome everyone. Just clicking through. So yeah, like I said, an overview. We're going to go through 6 points here. Just up top, we can't assume that everyone has the same kind of knowledge, so we do go, it is, I think, important to actually look at what a grow club is as an example of a private cannabis club. The grow club doesn't mean it's, the grow club model is a model of private cannabis club. So I think it's just important for people to understand that from a risk perspective, from people getting into the industry perspective. You know, the grow club model is not equal to, or is not the only kind of cannabis club. So we look at that distinction or subcategorizing. We then go very briefly into the events leading to the High Court's litigation. Then we look at in detail kind of the High Court proceedings. And I have chosen to actually lift a lot of portions of the judgment straight from the judgment so that you can see exactly how Judge Slingers ruled and how extensively she prohibited or forbidded or deemed as dealing the Grow Club model. And then we look at the possibility of an appeal, which I can tell you up front is underway. And then, you know, immediate implications and risks for clubs given the judgment, and then a little bit about the landscape going forward at the end. A little bit of, I wouldn't even call it housekeeping. I think I'll get through this and hopefully have time for questions at the end. Also feel free to leave questions in the chat and I will try, I'm doing this alone, so it's quite a few moving parts, but I'll try to answer your questions. And the chicken there is just to note that I actually live on a farm on the premises of a club here in Plettenberg Bay, and the chickens here seem to think that it's 6 a.m. all day, so might hear a bit of that, or duckies. With that, let's get cracking. So as I said, it's, I think, important to just understand or contextualize rather what a grow club is as an example or model of a private cannabis club. So private cannabis clubs, the umbrella in general, they arose as a result of the decriminalization of private cannabis use in our landmark judgment, the Prince judgment, and that's how I'll refer to it. We'll see, just so you know, when I lift portions out of the judgment, it says Prince 3. That's because there were previous Prince judgments in the Constitutional Court. And this Prince judgment, the privacy judgment, which I just referred to as Prince, maybe I should have just said Prince 3, it's the same judgment. And I'm not going to go into what Prince said here. Whether we like it or not, we have to reanalyze Prince in order to analyze this judgment, because the judge, basically Judge Slingers, was holding that the Grow Club model doesn't conform to Prince. So then what does Prince actually say? So those are key points. There's actually no enabling legal framework or compliance standards for private cannabis clubs. there are as many private cannabis clubs as there are founders, other than a few exceptions, which I'll show you. So yes, is it the Prince judgment, which interprets the Drugs Act alone, which gives us these kind of vague principles? The answer is yes. And so that's why we're in a tricky, creative space where people are doing interesting things. So it's that lacuna. Lacuna in the law is something where there's actually a lack of law. Sometimes people call it a loophole, but I think a loophole has negative implications sometimes. A lacuna is more accurate because it doesn't, a loophole suggests that something is not actually allowed, whereas we're here dealing with an absence of specific regulation in the context of the drugs laws, which are very firmly in place. And then, so a commonality amongst all private cannabis clubs are that they all entirely or partially at least grow cannabis for their users. The idea being that the rights in Prince, which we'll look at, that were granted by the Constitutional Court in 2018, they are futile for so many people, maybe even most people who use existing cannabis users who have never, for very legitimate reasons, grown cannabis or cannot, whether they're socioeconomically or physically or otherwise prevented from doing so, cultivate their very own cannabis all by themselves. So that's the commonality of private cannabis clubs. That's why they're there. That's why they exist. One may argue, and I would argue quite strongly, that it's actually a social good that needs to be in place. It's actually a public benefit, social and conscious and responsible cannabis use. And so a grow club model, which we'll look at right now, is a specific category or type of private cannabis club. And I've lifted here just pieces from the judgment where the judge actually told us what a grow club model is. On the pleadings and papers of the Haze Club itself, they characterize their grow club model. You can see in quotes here in that paragraph 5. It's a socialized system of cannabis cultivation in terms of which the applicants rent out space to the members by means of a sublease, wherein members grow their own cannabis for personal consumption while employing the applicants. The applicant mentioned again and again, obviously, is the Haze Club, because the applicant applied to the High Court, as professional horticulturalists to attend to the cultivation. And as we'll see, what they're looking for, it was a declaration that grow club model is lawful. And in summary, the judge was saying in paragraph 21, with a grow club model, the buyer does not purchase cannabis, but rather they purchase expertise together with the tools to cultivate the cannabis and rents out the space. The grow club members supply the applicant to the club with their feminized seeds, which the club then grows, harvests, and cures the plants for the member, individually tagged and traced throughout the growth cycle, so that if member X passes on their feminized seeds at all points, it is individually tagged and traced, and they then collect the yield of all of their individual plants. So yeah, just I see some of the guys like Quibus, Marlene, colleagues and friends. Yeah, just to contextualize, this circle here is just to characterize, the grow club model as one model of many potential cannabis clubs, private cannabis clubs. Grow One Africa has done a fantastic job at building their own very intricate compliance standards. There are many clubs, I think 30 plus, Quibus can correct me if I'm wrong, Grow One Africa clubs around the country. Excuse me, I'm just lost myself for a second. Around the country, and they have their own, as I say, intricate and clever compliance standards, which they have developed internally to conform with the Prince judgment, again, which we'll look at now. There's also the Grow Club model. Was established by smart lawyers, initially, I think, by Schindler's lawyers, and then interpreted by others and assisted by others. The Grow Club model tested in the Haze Club itself, I think there was elements added to it beyond the initial kind of establishment or formulation by Schindler's. There are a number of clubs around the country that conform with the Grow Club model. There's also the NCOD model, which is a Spanish developed and European Union model for clubs, which some, such as the club where I live here in Plettenberg Bay, the Canna Club, conforms to. There's also a manual which I developed along with Marlene, my colleague who's here on the call, Private Cannabis Club framework manual for the establishment, where we provide our models, which we have, and through legalese and elsewhere we have people who are conforming with those principles. And then those X's there are just to say there are many just individuals who start their club with or without legal and other assistance, who are just interpreting the same way that the lawyers and others are to conform. So that's just an understanding. Hopefully it gives you a bit of an understanding of around that. The Grow Club model is not every cannabis club. The Grow Club model is a kind of cannabis club. Now, briefly, the events leading to the High Court litigation. In October of 2020, the SAPs raided the Haze Club in Cape Town. They seized, according to the judgment, 340 or so plants, 2.5 kgs of dried cannabis valued at around R1 million. They arrested the THC director, that's Neil Little, who's doing a lot to fight this battle for all of us, alongside their great attorneys at Ward Brink, Andrew McPherson, who I've been in touch with since to provide as much support and solidarity as possible in these times since the judgment was handed down. And so that was the director, Neil Little, and an employee, Mr. Van Houten, who I think was a horticulturalist, a grower at the Haze Club, and they were charged with dealing in the magistrate's court. Cleverly then, they had to really, the THC applied to the High Court, so they said to the magistrate's court, hang on, we're applying for a declaration to a higher court, to the High Court system, that actually what we're doing is lawful. So we have to stay these proceedings, these criminal proceedings on the facts and exactly what we're doing and whether there was a contravention, until the High Court has actually ruled whether what we're doing is lawful or not. And so that's what they did. And that High Court proceedings, which culminated in the judgment on the 29th of August this year, has taken since essentially the end of 2020 until it was a long drawn out High Court process. And in those proceedings, what happened? Just being mindful of time. In the High Court proceedings, the THC is the applicant. Why? Because they applied, right, to the High Court, with the respondents being the Minister of Police, so the SAPs, and the National Director of Public Prosecutions, so the prosecuting authority, the Minister of Justice and Correctional Services, and also the Minister of Trade are the respondents. And the Haze Club, the applicant applied for a declaration, number one, that the Grow Club model, which we've characterized up top here, that it conforms actually to the contours of Prince. That Prince actually, if you look at Prince, it actually allows, and the ruling and the judgment itself, it allows for this model. And if it doesn't, so they ask for it's called alternative relief. Number one, that Prince sanctions what we're doing here in the Grow Club. If so, end of story, this is lawful. And if not, if Prince, in fact, if the court finds that Prince does not sanction what we're doing here in the Grow Club model, and specifically in the Haze Club, that by criminalizing, by not allowing it, by rendering it unlawful, that the Drugs Act, as interpreted by Prince, essentially creates a dispensation which is unconstitutional for other reasons, on the basis of other rights, not privacy. Remember, Prince was decided on the basis of privacy. That has been decided. But if the Grow Club model judge does not conform with Prince, then we submit, the applicants, the Haze Club submitted that dispensation created then unjustifiably violates the rights to equality, the rights to freedom of trade, and the right to bodily and psychological integrity. And we'll look at those. So it's just important to characterize the argument there up top. So on that first one, on the first relief sought, that actually Prince itself sanctions what we're doing here in the Grow Club model, we have to go back and look at Prince. And Section 4B of the Drugs Act, the Prince court held was unconstitutional. It prohibited the use and possession of cannabis by an adult. And they said, the Prince court, that Section 4B of the Act, prohibition against the use and possession of cannabis by an adult, is unconstitutional. Why? Because it makes the use or possession of cannabis in private by an adult person for his or her own consumption in private, a criminal offense, right? And when it came to the cultivation of cannabis in section 5B, plus the definition of dealing in the Drugs Act, because section 5B prohibits the dealing in drugs, such as cannabis, right? So you have to look at what the definition says. And in the definition of dealing in is included the element of cultivation, among many others, transmission, sale, supply, 14 or 50. It covers, it's very broad and anachronistic, and we are all complaining, you know, actually, in fact, our industry, in fact, can go nowhere unless this is amended and repealed. But in this case, yeah, cultivation is an aspect of dealing. And the Prince Court said that actually that is unconstitutional. Why? Because it prohibits the cultivation of cannabis by an adult in a private place for his or her personal consumption in private. So adults must be able, on the basis of privacy, the government has no legitimate interest in violating the privacy rights of individuals in the context of a rather harmless drug such as cannabis to these degrees. So individuals can cultivate, so people can cultivate, possess, and use cannabis for their own personal private consumption, is essentially what the court held. These very words become extremely important when we actually understand and look forward to an appeal, which is underway at the moment. In brief, therefore, the Haze Club argument is that the Grow Club, in terms of the Grow Club, all of the use and possession occurs via a lease, in a sublease to the member, in private grow areas, individually private areas, with sophisticated tagging and tracing, so that at all times that possession is done by the member and traceably to that member. And then on the cultivation side, there's no dealing. Remember, I said cultivation is an aspect of dealing in terms of the Drugs Act. So what the applicants, what the Haze Club, they argued is that there's no dealing or purchase in the seeds because the members deliver their feminized seeds or clones to the club. And it's just cultivation expertise that is provided to the member, which is what we call the agency construction. So the club is actually the agent of the member who grow, and therefore is in effect the member who is growing through the club's expertise. So the Minister of Police, the respondents' arguments, they came and said in response, no, on a possession level, the members do not possess at all. It's the Haze Club that possesses. All effective control of the plants are in the hands of the Haze Club and not the member. And the sublease does not actually give the member any possession, right? That's how they read it. Moreover, there are actually common areas where plants are kept together. So that actually belies the respondents. The respondents said the submission that everything happens in private bays. On the cultivation level, they've said the agency construction is illegal, and it just serves to lift exactly what the court there said. The SAPs, the respondents, argue that Prince 3 only permits the cultivation of cannabis by adults for his or her personal consumption in private. It does not allow the cultivation of cannabis belonging to another. That's the agency construction. One cannot grow on behalf of another. Therefore, the establishment of a grow club which keeps and grows cannabis for others is illegal. And they also said, obviously, because as a part of the Grow Club model, not every single member physically delivers their own seeds, the clones, the startup cannabis material for each member. Cannabis is sometimes donated by members to other members for the purposes of growth in the club. And so the Minister of Police, the respondents then argued that this donation, this gifting, is actually a form of dealing. So what did the judge say? She went slinging, as her name suggests. On a possession level, she 100% basically, there's almost no need to go into, she basically just said she agrees. It's also important to note that she was a former senior prosecutor with the prosecuting authority. So the way she potentially reads laws are informed from kind of a criminal enforcement perspective. So we see what happens in this case where she's actually 100% agreed with the applicants. And we can just go back to the previous page for her ruling. She says the effect, there's actually the members who come to the club have actually no control and no possession of their cannabis. They have very little. They have to, if they want to get permission if they want to access their plants, they have to get specific permission they don't have actually any effective control or supervision of their own plants. So this is actually a legal form of possession because they haven't themselves personally possessed the plants. On the cultivation level, similar kind of ruling. They're not actually cultivating whatsoever. There is no participation by the member, and in fact, the cultivation by the club is in itself an aspect of dealing in, which is not allowed. It's important, I think, also to note that the ruling is based, Slingers' ruling, the judge's ruling is based on the notion that what the Constitutional Court in Prince did was allow for the exercise of these rights only in the extreme inner sanctum of our privacy, in this inviolable inner sanctum. These are the constitutional philosophical words used by the Constitutional Court in privacy, other privacy cases. And what Judge Slingers has said here is that in Prince, they said that one can access these rights only in the inviolable inner sanctum, where essentially one acts entirely alone without association or socialization with others, right? She said, given the socialized nature of the Grow Club model, the individual has left behind this inviolable core of the inner sanctum of private space to enter in relationships with fellow members and the club, right? So these activities of the members of the Haze Club have acquired a social dimension. So she says you cannot associate with others. There is no way in which that your ability to exercise your rights to possess and cultivate cannabis for your own consumption exists outside of an inner sanctum where only you can actually exercise your rights. And so that, I think, is a big question. Did the Constitutional Court in Prince actually do that? I think definitely not. And so I think there's a ground for appeal there. Ultimately, what the judge is saying is that you have to read the Drugs Act interpreted by Prince extremely literally or formalistically, which I guess does make sense if you think about her experience as a senior prosecutor. The effect of this judgment is far-reaching. No one other than the very adult cannabis user can have anything to do with the ownership, possession, or cultivation of the user's cannabis plant. So what does that actually leave for us? Very little. The only way you can access, the court is saying here, the rights granted in terms of Prince, is if absolutely no one else has anything to do at any level whatsoever. No gardener can come to your garden and tend your cannabis plant, for example, just as one plant of many. You alone, by yourself, are the only person that can cultivate your plant for personal consumption, which is extremely far-reaching, and we as an industry think is very unconstitutional for these reasons as well. So even if the THC said, essentially what happened here, we're still dealing with number one, the first primary relief sought. The judge said no. In fact, the Grow Club model does not conform with the contours of Prince. Remember, they said it in the alternative. The Haze Club said, okay, fine, but then you must understand, Judge, that dispensation violates other important rights in the Constitution, namely the prohibition against discrimination under equality in Section 9(3) of the Constitution on the grounds of race and socioeconomic status, among others. They said, the THC came forward and said, most people in informal settlements, many people around the country do not have access to the requisite resources in order to cultivate for themselves. And so therefore this is actually amounts to indirect discrimination on the grounds of race. Then on the freedom of trade, the club itself and its horticulturalists employed by it, their rights to practice their freedom of trade or their trade of their choice and to practice it has been unjustifiably violated through this. And then many of the members of the clubs who actually use cannabis medicinally and for many in high stress, they cited the affidavit of one of their members who is an actuary in a super high stressed work environment that needed the club in order to access his rights and to kind of self-medicate his stress levels. So the right to bodily and psychological integrity therefore is implicated, and the THC says, unjustifiably violated, which would then render the grow club model allowed. So on the equality argument, essentially, you guys can read that if you like. The court is saying that the club itself, the membership fees in the center of Cape Town, I think it is, are actually expensive. And so for the Haze Club itself to come and allege a violation of the rights of the poor, they said, I think in the wording here, is opportunistic and stands to be rejected. So she actually just refused to deal with that, which I think is problematic, and we'll see hopefully in the appeal process a lot of evidence in this regard. And so that was simply how she dismissed that argument. And then in terms of the right to freedom of trade and to choose your practice and profession and occupation, I think it serves actually to read this with or to you guys. In the light of the shared characteristics between a dealer of cannabis and the grow club model, the limitation on the applicant's right to choose a trade profession, etc., is reasonable. By allowing the club, either by way of a grow club or as a cannabis horticulturalist, to cultivate cannabis on a large scale for consumption by others, would basically condone dealing, very similar to the manner in which allowing the purchase of cannabis would be condoning dealing. The constitutional courts in Prince recognize that dealing is a serious problem in our country, and therefore ultimately it's a justifiable violation of people's rights to be horticulturalists and to run clubs, because dealing, the Prince court said, is still a big problem, and therefore, and because cultivation in the opinion of the judge is tantamount or an element very formalistically, without going into any evidence really, is an aspect of dealing, the violation of the right to practice your trade or profession of choice is justifiably limited. It's okay, because cannabis is the dealing in cannabis is still a serious problem in this country, according to the judge. To allow the grow club model to operate in the absence of statutory and other regulations could have the practical effect of legalizing dealing. It may be the legislature envisages the legislation in future, but that the court cannot anticipate it. The legislation of dealing in cannabis concerns policy issues and fall within the realm of the legislature and not the judiciary. So here she's abdicated all kind of judicial authority and responsibility to say that this is a policy-centric issue that one judge listening to one matter cannot make. It's up to the legislature to look at the commercialization of cannabis and potentially clubs, and to make that type of decision. So she really just kind of abdicated responsibility from really taking a step forward and reading the legislation purposively and constitutionally to allow people who can't cultivate for themselves to access their rights. And then simply on the right to bodily and psychological integrity, she basically just says that people there's been no evidence laid by the Haze Club, by the applicants, that it's difficult to grow for yourself, and that basically the convenience that one has the right to put some seeds in the ground, but that one doesn't have the right to super good weed, and that there's no evidence that it's difficult for people to cultivate cannabis. So she really didn't look at the evidence and just took the respondents, the Minister of Police's kind of word for it. She says the applicants and their customers are not prevented from using or cultivating cannabis. And this is the crux of the matter. They are merely prevented from outsourcing that right. So this is the judgment. And so frantically, the industry at large all got together in quite a beautiful way, pulled our heads, and the matter had to be fought, which Ward Brink attorneys and the Haze Club and Andrew Little lodged an appeal on the 19th of September in time, right? And the question is, what are the possible grounds for the appeal? Many is the answer. She wants the judge to read Prince literally. So I can take you back to, let's go back to this page 14, for example. She made a big deal, the judge, of reading Prince literally. So here's the wording of Prince, right? So if you look at the underlined portions, yeah, let's look at in the cultivation of cannabis part. if we look at what is allowed, right, is the cultivation of cannabis by an adult in a private place for his or her personal consumption in private, right? What is the effect of the ruling? The effect of the ruling is that the cultivation must take place personally by the member, by anyone seeking to access these rights, whether it's a member of a club or anyone else, right? But if we want to read the judgment literally, well, then look where the word personal, what does the word personal actually qualify here? The word personal, if we look at it, actually qualifies the words consumption in private. It doesn't actually qualify the cultivation itself. Similarly, in relation to the possession up top. For his or her own personal consumption, for his or her personal actually only qualifies the consumption part. So when it comes to the possession aspect, the court, I believe in Prince, was very careful not to double that up, because it knew potentially that if it qualified the possession and the cultivation with the word personal, then it potentially would have locked it into that. And the Constitutional Court is a bench of extremely smart people and sensitive people. So the argument goes, you know, if we want to read, if you're telling us to read the Prince judgment literally, Honorable Judge Slingers, then let's do that. Potentially there is grounds to argue why, in fact, the outsourcing of the right on a literal interpretation of the Prince judgment is actually okay. The personal comes behind the consumption. So perhaps we can outsource that right if the word personal doesn't also qualify the cultivation and possession. Of course, in the appeal, which actually was heard, the appeal hearing was heard today. I've been in touch with Andrew. He thinks it's gone quite well, which is fantastic news. So the standard of proof, or the burden, I should say, to show why an appeal should be allowed, you have to show that there are reasonable prospects that the judgment could be appealed. And so Andrew has said it's gone quite well today, which is great, and potentially the appeal should hopefully be granted. Whether it is granted to the Supreme Court or the Constitutional Court will be decided not yet. But the judge herself, Andrew seems to think, well, at least the hearing went well, that she will likely allow an appeal of her own judgment, right? Other grounds are potentially the freedom of association, which hasn't been relied on in this judgment or in the proceedings so far. We've said that, just looking at time, we've said that, you know, the Judge Slingers has ruled that as soon as you leave your inviolable inner sanctum, where only you are privacy, where there's only you, let's say, to be crude, for example, watching porn. That is a classical example, or the home environment with family. That's an inviolable inner sanctum, right? Not watching porn with the family, like watching porn or being at home with the family. Those are spaces that are deemed to be inviolable spaces, right? And that the judge in this case says, as soon as you leave that, well, then you enter into the world of socializing and the public domain. But that doesn't mean that once you leave that domain, you have no right to privacy. It means that your legitimate expectation to privacy starts to diminish, right? And so where I think she has got the Prince judgment wrong here is she's actually said that the exercise of these cannabis rights have to take place in this inviolable inner sanctum. And if you look at the Constitutional Court and read it and reread it, I think the court was very careful not to try and specifically locate where the exercise of these rights take place. So there's another potential ground there. Of course, when we're looking at what's the commonality of all private cannabis clubs, it's an attempt to assist people who cannot grow for themselves to grow for themselves. So, and the judge in this ruling has for the reasons that we've discussed, refused really to look into that evidence. So there's a lot of constitutional reasons why these clubs need to exist, why private cannabis clubs need to exist. And in the appeal, it's hoped, and for sure, it will be very strongly argued how these clubs are in pursuance of those rights. As I said, the appeal hearing was actually today, and Andrew, I've been in touch with Andrew, who said it went well, which is fantastic. And so hopefully it's a matter of course that the appeal will be granted. The hearing was today and it went well. So what are the implications and risks of the actual judgment on existing cannabis clubs? It's a big question. I mean, as soon as the judgment was handed down, just looking at time, we were all understandably in quite frantic. What does that mean for all of the clients out there with clubs? Do they have to shut down? For how long? Are people potentially looking to open clubs? Must they give up their hopes and dreams and do something else? It's a big deal. I think Grow One Africa alone employs over 1,000 people. There are thousands and thousands of people and taxpayers who are contributing to the fiscus who are at risk here. So I think firstly, it's important to note that in terms of the Superior Courts Act, the legal question as to whether the Grow Club model is allowed is now still open, because the moment in terms of the Superior Courts Act that you lodge an application for leave to appeal, that stays the effectiveness or the enforcement, I should say, of the judgment or quo of the High Court judgment, right? So the High Court judgment and the decision and the illegality of the agency construction and the Grow Club model is still in question. The legal question is still open. So what does that mean? Well, that means arguably that the risks from the inherent risks of opening and running a private cannabis club or Grow Club model, it becomes important to now distinguish which one you're looking to operate and run, is no more riskier than it was before the judgment was handed down or a year ago, for example. The SAPS and the prosecuting authority has always viewed clubs as illegal. Is there really a change going on here? The argument is, and the reality is, that there's no increased legal risk. It's not to be gung-ho and to say to people, well, this presents an opportunity, but the point is that the risk has gone nowhere. It's still there. It's still risky business, but it's the same as it was before, is the argument. And so what might happen if you as a cannabis club operator or intended operator came before a court? Well, essentially, if your club was one in terms of which, whether it was a Grow Club exactly or not, whether if your club followed a model in terms of which the club grows on behalf of its members, so the agency construction, which is what is the central kind of focus of this judgment, which was deemed to be illegal. So if you do that, that legal question is still open. So if you were raided, which is a terrible experience, and you were arrested, which is a terrible experience, but as I say, the risks there haven't changed because of this judgment. So those experiences are still inherent and terrible to go through. A magistrate would not necessarily be able to convict you because the legal question still looms large, assuming, in fact, that your club, for example, grows on behalf of others. I hope that's understood, and I'll potentially go into questions along that. And also then you have to, as I say, differentiate that leads to the question of, like, what model are you looking at? Whether it's you as a member, as a club, or an intended or existing club owner or runner. It becomes important to now understand and really look at the Prince judgment and see whether the Grow Club model is exactly what you want to run. On the one hand, the Grow Club model does have this sort of, if you kind of argue before a magistrate that you're following the Grow Club model exactly, there's potentially a higher likelihood that magistrate will say, oh yes, well, it exactly conforms to the contours of a Grow Club model, and that is actually a legal question that is being decided in either, on an appeal to a full bench of the High Court or the Supreme Court or the Constitutional Court, and I don't have the power to actually make this decision, versus a spectrum of other models. And so this becomes an important question to ask. We can hopefully deal with some of these questions in the Q&A because I'm going to round up soon. Of course, you're always most welcome to get in touch with me here at Legalese whenever you like to look at these questions more deeply, if you are in fact an existing or intended club operator. And going forward, it's always just important to contextualize the industry in general. As I said, the Drugs Act largely still pretty much criminalizes, other than the extremely expensive and barriers to entry sector, or the sector characterized by high barriers to entry, being the medicinal sector. in many ways, of course, the hemp sector is now up and running, and it's interesting. But in many ways, one could still argue that the Drugs Act basically renders and it in fact straitjackets the progression and the coming online, the meaningful coming online of an inclusive cannabis economy. For one thing, this appeal process, both parties have said since the first day in the High Court that they're both going to appeal all the way up to the Constitutional Court, which, if true, will take. The High Court matter took a year and a half, so we're looking at at least another year of litigious proceedings before a decision is made. At the same time, we know that the Cannabis for Private Purposes Bill, which will have, whether we like it or not, and whether the legislature and the parliamentary committee, which is of the Justice Department, likes it or not, it's going to have a direct implication on clubs. Our opinion, or my opinion, is that it's going to be slightly more permissive in the club space, and it also is going to remove the reference. The bill is going to remove reference to cannabis in the Drugs Act. So that will be a big step forward. Whether we like the bill as from a constitutional perspective is a whole nother question, subject to huge criticism. I'm just talking here in relation to clubs. There are many, I think, reasonable arguments that the bill will potentially make the running of clubs a bit easier from a legal perspective. And if this bill is passed before the appeal process in its entirety has finished, well, that might have an effect on the outcome of the case itself. And then, of course, general commercialization. We must understand that clubs do not operate in the commercial in commercial cannabis context, meaning that one may not profit from, which is again always a heart and soul of any question when it comes to developing a model itself, because one may not profit from the exchange of ownership of cannabis. So the commercialization of the actual adult use market, the responsible adult use market, is something that is being contemplated in the bill, but is also quite a long way off. And so cannabis clubs are, I think, here to stay for the immediate future. And it's therefore imperative that we get together as an industry and sector and ensure that our clubs run legitimately, with a genuine attempt to conform with the Prince judgment in the absence of clear regulations to that effect. And that, yeah, the club's relevance really, we think, is going, it's a very relevant part of our economy, we think now, and it assists people to exercise their very important rights to constitutional privacy in using their own cannabis for personal use. And so whether or not commercialization comes in 2 or 3 years, clubs, we think, are here to stay as a way of responsibly accessing cannabis for private use. And I think, please, yeah, here's some contact details. If you want to get in touch with us at Legalese, feel free to do so. Or just at the Legalese website, legalese.co.za. And I think with that, I'm going to open, because I know it's 1:45. I'm going to look at the Q&A first and see if there's specific. Oh, thanks, Kobus. 22 Goa clubs. So I'm going to look at some of the chats, what people said in the chat, and then potentially, if people want to open up through voice, we'll do that if people have the appetite for that. Wandile Marumole says, hi there, how's it, Wandile? Will there be a recording of this webinar? Yes, it is recorded, and I'm pretty sure I think it goes up onto our blog and potentially to YouTube. So just have a look out for that. Thank you, Kobus. It's lekker to see you here, man. 22 Goa clubs, 131. It will go up on YouTube. Thank you, Kyle. Webinar. 131 cultivating and processing members. So remember, and Kobus, please correct me if I'm wrong, in terms of the Grow One Africa model, there are clubs which are independent from their growers, and then there are the members, the people of the public who access them. And what the Grow One Africa model is, very cleverly ties the growers' supply to the club and to the member. I mean, so they have 131 cultivating and processing members throughout the country and 1,200 jobs created. So on my last point, and that's just one group of clubs in South Africa, albeit our biggest one, but it's one group. So thanks for that, Kobus. Kyle says, to what extent do I agree or disagree with the judge's definition of a grow club? Could there be a better definition? And if the freedom of association wasn't erased, then can it be raised during appeal? Both excellent questions. I think on the first one, Kylo, colleague and head of commercial at Legalese. So that definition, it's not really a matter of us criticizing the definition of the grow club. The grow club is the model that they themselves elected the Haze Club to pursue, right? And which was characterized by in the courts, unless I'm understanding more correctly, your question is asking whether the use of the word club or grow club is a good term. And I think that there's, and I have this discussion all the time with colleagues, specifically Marlene, who I co-wrote our manual with, and we think that to characterize a grow club as a club is misleading. There's nothing, I think the industry at large agrees that there's nothing that the grow club should be allowed. But in fact, it's a for-profit business. That doesn't mean that cannabis is dealt in. That doesn't mean that there's an exchange of profit, exchange of cannabis for profit. But there is an exchange of services for profit, right? So to call it a club or an association of members, much like you'd have a motorcycle club, a ski club, all these types of things, a non-profit club, it's not. So I'm not sure, Carlo, whether I'm picking up what you're putting down, but there's potentially a side point to be made that it's a PTY. The Haze Club is a PTY Ltd. It's a for-profit company, which is legitimately making money from services rendered in relation to its members' plants. And this is the subject, obviously, of the appeal process. But maybe there's a smarter way, it's a grow service, or however you'd like to call it potentially. But maybe the word club is misleading. And then you've asked, Carlo, if the freedom of association wasn't raised in the court or quo, then can it be raised during the appeal? Excellent question. You're right. It cannot be raised, well, it cannot easily be raised as a self-standing constitutional ground, right? Remember, in this judgment, the judge dealt with, does the GCM, the Grow Club model, fit within Prince? The answer was no. Then they dealt with the constitutional, the alternative relief, equality, bodily and psychological integrity, and the freedom of trade, right? You're right. Now to expand that to the freedom of association, which is critical here, I think in this judgment, or the absence of those arguments is critical here. It's harder just to expand because for the Supreme Court, for example, to look at the High Court judgment, which didn't actually canvass these arguments, there's a good chance it won't allow it. But, Carl, I do think there is grounds to argue on the basis of the primary relief sought, on the basis of why the Grow Club model should actually, why Prince actually does sanction the Grow Club model. I think a Supreme Court looking at it might allow arguments to the extent that the right to privacy is actually indivisible from and a corollary to the freedom of association. When as soon as you start to exit that inviolable inner sanctum of privacy, the right to freedom of association is there and operating, right? And in order to understand the protectability of your right to privacy, we have to understand the meaningful application of your right to freely associate and still in private. So it's a great question. I think if on appeal they deal with it perhaps in that way, that it actually forms part of the privacy argument, and the argument therefore as to why Prince does allow the Grow Club model, they might allow the freedom of association in that way, is my answer to that. Then I do see some hands up. As long as there's still 17 participants, which is lekker plus 8 minutes technically. So I am struggling to, a hand up, Werner Smith. I'm not allowed to talk. How's it, Werner?
How's it, Brad?
How are you doing?
I'm unmuted. I'm on my phone, so I'm having some difficulty with writing messages and stuff.
No, you're good. You're good.
Okay, cool. Thanks a lot. It was a very interesting webinar. I'm an attorney in Knysna, and I do some work with Grow One Africa.
Awesome.
So I think my comment relates to the questions I keep getting, and that's mostly centered around what the implications of this judgment are for other clubs.
Yeah.
And the way I read it, the grow club model, as defined, is the way that the Haze Club defines their grow club model. And as you rightly point out, they're a business. They're a PTY limited. It's not really a club. It's possibly a bit misleading to call themselves that. But the point is that this judgment, the application was for a declarator specific to their model. And the judge found that they didn't make out a case for the relief sought. So on that basis, I think the risk for other clubs it's not that great. The Haze Club sought an order declaring their specific model to fall within the ambit of Prince 3, which it probably doesn't. So that judgment might have been correct. And the alternative relief sought, I think they raised in the wrong forum and in the wrong way. So from a legal point of view, you'll know if there's a reasonable possibility of a material dispute of fact arising, then application proceedings aren't appropriate. And their alternative relief or their alternative prayers were essentially dismissed because the respondents just created a material dispute of facts, and based on the laws of evidence, the judge had to accept the respondent's version. So she couldn't really deal with the merits of it. She couldn't go into any of the arguments or the constitutionality of the legislation. So I'd be interested to hear your thoughts on that. Should they perhaps have rather gone the route of action proceedings instead of an application?
Brilliant, Werner.
That's about it.
Thank you. Yeah, brilliant. I think firstly, you're in Nasna, so we should grab a coffee and discuss all these things in person. But for now, on the increased risk, where you're not a grow club or pursuing that model, I agree completely with you. The risk is definitely lower. I just think from a level, a lot of the guys potentially here on this webinar and out there looking to start clubs, they're looking at risks of raid and arrest. So often we're only given a chance to when you're talking about a risk that includes the risk of being raided, arrested, and then only then coming before a magistrate and having your say. So up to that point, it is up to that point where I would say the risk actually isn't increased, because as I said before, the appeal process has stayed the enforceability of this judgment. So, but that risk is still very much there, as it always has been. But once I agree with you completely, once you are appearing in court, it makes a very big difference what model you are pursuing, as I surely agree, and I think I said in the webinar itself. So absolutely agree with you there. It becomes incredibly important as club starters, founders, and runners, operators to extremely carefully look at the model that you're looking to set up for that reason. So I agree completely. I think also then on your very astute technical legal observations, it would have been better to conduct action proceedings. It's possible though that by doing so, maybe the applicant, the club, has shot themselves in the foot, but I think there was something of not urgency, but they wanted to deal with this matter in an application way to potentially avoid the drawn out discovery evidence, etc., aspects of an action proceeding itself. Sorry, not discovery necessarily, but all of the evidential hurdles that go with an action proceedings and leading evidence and all of those things. So they wanted to basically deal with it all on paper via affidavit, as I understand. So I think, but I agree with you. I think it would have taken a lot longer, right? But it might have been better, because it would have allowed the judge to look into all of this evidence, because it is all about an action proceeding at the end of the day, a material dispute of fact, as you rightly point out. I do though think that on appeal, it'll be interesting to see if amicus curiae, so friends of the court, so for the other guys out there, where on an appeal, in a process, in the court proceedings in general, where people have an interest in a matter but don't come from the exact same perspective of the applicant in the matter or the respondent, they're allowed to appeal to make submissions from a related and important perspective that doesn't come from one of the parties' very own perspective, right? So I think, Bernard, perhaps to answer your question a bit, that the possibility or the opportunity that amicus can enter the fray here. Let's even say, for example, Grow One, Quibus wants to become an amicus, or Fields of Green for All, one of the many important kind of NGOs in the cannabis space want to join in the matter and give legitimate kind of evidence as to why people in the informal settlements, for example, can't access these rights, etc. Then I think that might allow the court on appeal to consider those submissions, and perhaps that was taken into account by Andrew and the by the THC when launching these proceedings initially. I don't know if that provides some sort of, it doesn't provide as in-depth opportunity as putting people in the dock and questioning and cross-questioning them does, but it still does give some sort of an opportunity. So I'm hoping, and I think that might allay that very, very real and good observation that and challenge that you've raised. I'm looking for other hands. I don't see any. I think it's 12:59, which is pretty awesome. And I'm going to say thank you. Thank you to everyone for joining. It's so fantastic to have a nice numbers of audiences. The video, as Carl says, will go up on YouTube. And it's been wonderful kind of being here with you all. Have a beautiful day. And that's it for now. Cheers, guys. I'm gonna close the webinar off now.